Thanks, Commissioners. O'Brien's my name. I represent Dylan Voller.
Yes, Mr. O'Brien.
I've been given a very short period of time, and most of my questions can be answered really briefly, so I'd appreciate if you gave it your best shot to answer with as much precision as you can and with as much brevity as you're able to muster. Can you do that for me?
I'd like to think I can answer them though, Mr. O'Brien, and be heard.
Good. Now, I want to first of all ask you about the incident involving my client and Mr. Morgan. You know what I'm talking about?
Yes, I do.
Yeah, my client was 13 and 1 month in age, and you know that he was lifted by the neck, carried and thrown with force onto a mat floor.
Yes, well, I gave evidence on this on Wednesday.
Yep. No, I don't want to ask you too many questions, except that you agree. I think you agreed when you first became aware of this, and you agree now that that behaviour was completely unacceptable use of physical force.
Yes, and I understood that we'd terminated Mr. Morgan's contract.
Well, in fact, it was allowed to expire. That's the situation, isn't it?
I'll retract that. I understood that we finished with Mr. Morgan's services.
Yeah.
You don't need to traverse all of that.
I'm not going to. I really don't want to.
No, good.
But if the answer's incorrect, I'm going to correct him.
Oh, of course.
Now, you were alerted to this and many other instances involving my client in April of 2012 by the Children's Commissioner, correct?
Yes, yep.
Now, and indeed, when you came to be aware of that matter, you were notified that it was, you thought that it was unacceptable he'd be allowed to continue in his position of employment, although you knew that that had happened.
This was Mr. Morgan?
Yes.
Yes.
And you accept also that it was unacceptable that your management did not report that matter to the police immediately, correct?
Yes, that's right. In
fact, that was said to be by the Commissioner, when you learnt about it, a breach of the mandatory reporting obligations that they had as departmental members, correct?
Yes.
And that was unacceptable to your mind?
It was.
Thank you. In relation to the matter of Tasker, my client was 13 and 3 months when Mr. Tasker was charged with an incident related to when he was 13 and 3, when Mr. Tasker was charged with aggravated assault upon him, correct?
Yes.
And you gave evidence for the defence in those proceedings, am I right?
I did.
Now, in relation to that, you also spoke openly to the press and defended your youth justice officer in the media, am I right?
If you say, I don't recall doing that media, but if I did, I did.
Well, it's a matter of public record, sir, and I suggest that's the case. You spoke to the ABC media when the matter was afoot.
Well, I spoke to the media on a regular basis, so if it was a media event, I take it I spoke. And I do recall, sorry, there was an ABC, I think it was a 7:30 report coverage on that, and I remember, I do remember doing an interview with that, yes. And
you are aware that in relation to those proceedings, the police had enormous difficulties obtaining footage regarding the incident?
Yes, but that really wasn't brought to my attention till very late in the piece, and by that time they had that information. But I also know that there was difficulties with that recording system trying to get information extracted from that.
And you're aware that the Children's Commissioner has suggested in no uncertain terms that staff the staff who were employed by the department had given false information in statutory declarations and affidavits related to the provision of footage to the police.
I know that the Children's Commissioner made those comments, yes.
Yep. And you know that in relation to that matter, the police eventually did get the CCTV footage, but it came almost 1 year after the incident had taken place.
Yes, I know that now, but I mean, no one approached me and asked me about that. I mean, we would have dispatched somebody, and I would say this, I don't think the staff were trying to cover something up. If they were, they could have easily erased that footage off the system. Let
me. You know that the Children's Commissioner was eventually provided CCTV footage from the Professional Service Standards Unit?
Yes, I understand that.
And you're aware that when the police went to subpoena the very same email from the PSU, the footage had been deleted?
I'm not aware of that. I understood that the footage was provided to the police. And I know we got quite a bit of criticism from the magistrate doing it over the supply of that footage.
I want to tell you the source of that information. That was the evidence that the officer in charge of this investigation gave to Magistrate Trigg in the task of prosecution. Do you understand that?
I'm not sure how it came about, but I know that we got criticised by Mr. Trigg.
A moment ago, you suggested you don't believe that the staff in your office did try to withhold or conceal evidence from police in relation to this investigation. I'm going to suggest to you that's exactly what happened.
I don't think they deliberately did, and I think if they were trying to do that, they would have deleted it off the system.
In any event, you are aware that there have been very stern allegations levelled against the officers in your department in relation to that investigation, correct?
Yes, I am aware of that.
Now, you're also aware, I imagine, I would hope, examined the judgment of Magistrate Trigg, that there were very significant problems that emerged in relation to the documentation as to what had occurred on the day of the incident, correct?
Yes, that's right.
In fact, the magistrate was so unimpressed with the material that had been produced by your office in relation to the incident that he was unable to place any weight on the credibility or veracity of the material. That was the effect of his judgment and pronouncement, correct?
It wasn't my office that did that. That was our department, and it was the Alice Springs Youth Justice Centre.
Well, quite contrary, to the contrary, I want to suggest to you that that was material which was produced from your office on a subpoena from the prosecution.
From the Professional Standards Unit?
From there or from your office?
Well, it wouldn't have been from my office. I mean, I didn't hold records like that. It would have been from the Professional Standards Unit.
There were difficulties in relation to the dates and times and alteration of those, according to the judgment.
That wouldn't have come from my office.
He found numerous errors and inaccuracies in relation to the documents as to what had taken place on that day relating to my client.
I think he's talking about the reports at the detention centre level.
Yes.
We have, I just rise to some concern. A document has been cross-examined upon. Witness should have access to the document, be taken to those areas. I don't have the document in front of me, but it's just concern about things right, departments, whether the allegation was in relation to his office, department generally, or what have you.
This is a public judgment, as I understand it.
Of course it is.
If there is any misnomenclature about department and office, then perhaps that can be corrected, Mr. O'Brien, if that's the gravamen of your objection, Mr. Tippett. Otherwise, it's a judgment that should be readily available.
That and the opportunity of the witness to go through. Of course, it's a public document, but it's not his document. And the last time the witness may have had reference to that document, quite some time ago, asking a witness to deal with a document and its contents from memory, in my submission, that's unfair.
No, he's not doing. Mr. O'Brien's not asking him to do anything from memory. He's putting certain propositions that were part of the findings of the magistrate in the judgment, which relate to the operation of an essential part of the corrections department. Mr. Middlebrook doesn't have to have known about it before. He's just going to be asked some questions, I suspect, at the end as a result of these findings. Let's see where it's going, Mr. Tippett.
May, please.
Yes.
So we are talking about documents that came from the Arundel House Detention Centre itself, you understand?
Yes.
And he found that there was information contained within incident reports which were plainly inconsistent with the CCTV footage, didn't he?
I can't recall those, but I do know that he was critical of documentation, but he found Mr. Tasker not guilty.
Well, leaving that aside, that's not what I'm asking you about. He said the documents and records of the Youth Detention Centre are not particularly complete nor accurate. That was his assessment.
And I'd agree with that.
Yeah. Now, in the report that you came to receive from Howard Bath, documenting all and each of these instances that you did in April of 2012, there was a similar commentary that the documents and reporting had not been accurately or done with any level of precision, correct?
Yes, that was a pretty common theme.
And yesterday we heard from the minister, the previous minister, Mr. Elfring, your superior, who told the Royal Commission that he was contacted by Dr. Barth on the 23rd of August.
We were dealing with it.
And you see the very same problems in relation to documentation, in relation to staff training, in relation to excessive and questioning the lawfulness of isolation were raised in those reports, as were raised almost 2 years earlier, almost 2.5 years earlier, with you, correct?
Yes.
But they were ongoing, and you knew that these things were not historical because they were related in some way. At least isolation was related. The use of isolation was related to the gassing incident, correct?
And we were dealing and trying to manage those things.
So coming to that involvement that you had with Mr. Tasker in the prosecution of that case, and you're giving evidence for the defence in that matter, do you understand that at least gave a view to the public at large that you were partisan in protecting the staff in these sort of incidents as against assisting in the welfare of the children?
Yes, I was aware of that, and also Mr. Tasker was doing what he was instructed to do by his superintendent, and I felt an obligation to support him with that.
And you're aware that notwithstanding those two judgments by Magistrate Trigg and by Justice Barr, the Children's Commissioner still determined, with the assistance of expert advice, that the exercise of force by Mr. Tasker was unwarranted, excessive and dangerous use of force against Dylan Voller.
Well, object to the question because it brings into question decisions of two courts of the Northern Territory in relation to that matter.
Well, it doesn't at all. It accepts the premise that they were made.
I'll finish my objection. I won't be a moment. And that he should not be permitted to go behind that. And at what point? Mr. Middlebrook has these two decisions on the record as Commissioner. He's not entitled to go behind either.
I'm not sure about that, Mr. Chipper. This is about responsive conduct by the Commissioner. There may have been another body of evidence that Dr. Barth saw that wasn't before the court. They're not questions about going behind the judgment in the way that it's understood in the courts. This is for a different purpose altogether, so the objection is not upheld.
You want me to ask the question again?
Yes, please.
So the effect of the question was that the Children's Commissioner had the benefit of these two judgments in relation to Tasker and had the benefit also of experts who he had commissioned to examine the footage and concluded that there was an unwarranted, excessive and dangerous use of force in this instance against Dylan Voller.
Well, I consider that both Magistrate Birch and Justice Barr had the benefit of experts as well, and I accepted their ruling on that particular incident.
Well, I'm going to take you up on that. Neither of them heard evidence from experts. Do you understand that?
Well, I accept the ruling of both the local court and the Supreme Court.
This Royal Commission has had the benefit of experts in relation to this, and Mr. D'Souza says that this was totally inconsistent with part principles, which should have been exercised by the youth workers in restraining children.
With the greatest respect, Mr. D'Souza wasn't there on the night, and I was supporting Mr. Tasker basically because he was doing what he was instructed to do by his superintendent. We effectively changed some of the practices after that. And if you're asking me about whether I was totally happy about that particular incident, no. But Mr. Tasker did what he was instructed to do by a senior officer. You
did something after the incident or after the judgment? Because there's a very big time gap between.
Yeah, no, I asked for a review of the at-risk policy, and the at-risk policy was reviewed right across for both adults and the juveniles.
Dr. Barr has said that you were overly focused with the criminal response as opposed to looking at, quote, ethical issues as to whether they were ethical, culturally appropriate, harmful to the young people, or complied with internal policy, training, accepted best practice in corrections, or human rights obligations. That's a fair call against you, isn't it?
That's Dr. Barr's opinion.
Because no action was taken in relation to Mr. Tasker, was there?
No, there was not.
I want to ask you about Mr. Nipsell. Mr. Nipsell slapped Dylan Voller to the face, causing him to fall to the floor. Remember that?
Yes, and he was stood down.
My client Dylan was 13 and a half years of age.
Yes. and
You've seen
Mr.
the footage.
Yes, and Mr. Nipsell was stood down immediately. And from memory, I think it was referred to the police as well, I think.
Nipsell, in fact, was working within 2 years of that incident back with the department as a youth justice officer, sir.
And I didn't approve that.
You actually didn't even know about it.
I didn't know about it, no.
Well, that's an absolute disgrace.
Well, you know, I mean, I don't know how that happened. It fell through, and I agree with you. It should never have happened, but it certainly wasn't with my sanction.
Well, it happened under your watch.
Well, it happened, but it shouldn't have happened.
In fact, he was working with Dylan Voller in the years after this event, after he slapped this child to the face, a 13-year-old child who fell over as a result of the force that being used.
Mr. O'Brien, I had an executive director and a director and an assistant general manager. It's a little difficult sometimes when you're sitting looking over the global issues of the department. Let me finish, please. It's difficult to try and have your finger on the pulse and everything when there's so much happening in the organisation. Now, I wasn't happy that that happened. It should never have happened. And, you know, I'm not sure where that finished, but I think it was certainly a problem in the way that Mr. Nipsell was re-employed.
You said a moment ago that he left the job. You know that not to be true, don't you?
Who left the job? Mr. Nipsell?
Nipsell.
No, I think we suspended him from memory.
But I've just told you he's back at work within 2 years.
He didn't say he left the job. I don't think he said he left the job. I think they said they stood him down.
We stood down, and I understood that there was a disciplinary process, or he was charged with the police, but I don't think he was convicted. I'm not sure of what the circumstances were. I can't quite recall it, but I certainly didn't employ him back.
On the 4th of October 2011, Mr. Tasker was involved in another incident with two other youth officers at the Alice Springs Youth Detention Centre, which came to be considered by the Children's Commissioner. You're aware of that?
Can you just refresh my memory on that incident?
Can we have those photos shown to the witness? This is the incident where 3 officers came into the cell, again put Mr. Dylan Voller to the floor. This time Mr. Tasker had Dylan's arm upstretched and in an awkward position. On this occasion, again, he was stripped naked. Do you remember this incident? Can I show you some photos?
Yeah, you might. Look, I don't actually recall it, but I know that Mr. Voller would often threaten self-harm and had a propensity to spitting on the staff. Now,
I'll show you a set of photos so that you're clear that we're talking about the right incident. Just in fairness to you, I've turned up the pages. No need for them to be shown on the screen. I think everyone else is with us as to what we're talking about. Are you with me?
Oh, yeah.
Yeah. So you understand that again, the Children's Commissioner commissioned an expert, and the Children's Commissioner agreed with the expert in finding that this was a further example of inappropriate force being used against a child during an at-risk procedure. You remember that finding?
Yes, I do recall.
You agree with that finding?
Yeah.
You agree with that finding?
I don't know whether I agree with the finding, but, you know, when you've got a difficult situation and somebody's threatening self-harm, these young people, they've got to be managed. Their safety's got to be protected. They've got to be managed in an inhumane and not in a cruel way. Am I right about that? I agree that, but you know, I believe that they've got to be protected sometimes from their own actions.
And when an expert says, and when the Children's Commissioner says it was inappropriate force being used during an at-risk procedure, are you prepared to accept that or not?
Depend who the expert is. I'm not sure now who Dr. Barth had used as an independent expert.
The expert was a Mr. Unger who was training your training your staff, including the trainers of your staff.
Well, I hadn't heard from Mr. Unger, and I'm not sure. I remember the report from Dr. Barth, however. And in relation to the report from Dr. Barth, which you were to learn about in April of 2012, he regarded this as a systemic problem. I think it was the difficulty in dealing with one individual.
You, at that stage, sir, were in charge of a youth detention system that was traumatising and re-traumatising already traumatised children who threatened to kill themselves or hurt themselves, weren't you?
No.
I want to ask you about isolation. You said in your evidence earlier this week that the problems in the BMU and children being held within the BMU was principally a problem around August of 2014. Do you agree with that?
Yes.
Now, are you aware that in April of 2014, between the 9th of April and the 28th of April 2014, my client was held 19 days in the BMU?
I'm not aware that was consecutive, if that was consecutive.
He was held further from the 15th of August 2014 to the 21st of August 2014, that period of 6 days in the BMU.
Again, I'm not aware of that if it was consecutive.
I'm suggesting, sir, that they were consecutive periods. We're aware of that.
Well, have you got any documents that have got my approvals with that, or any emails that suggest I approved the extension of any placements?
No, because, sir, what I'm suggesting to you is that the view of the staff working under you was that they didn't need your approvals to roll these over under intensive management plans.
That's not correct.
Yeah. In fact, you gave evidence to the effect earlier this week that you didn't understand that your directives were being used as IMPs, keeping these kids isolated and locked up by themselves day after day after day after day. Is that the case?
Well, there was no evidence of that during some of the audits that were being done, but the problem with that was there was insufficient records as well.
Yeah, again, the record keeping was substandard, right?
Yes, I accept that.
Yeah, so we're all the way from 2010, when Magistrate Trigg had an opportunity looking at documents from that period of time, all the way till 2014, the documentation system didn't improve, did it?
No. It didn't.
Systematic failing, isn't it?
Well, it's about resourcing as well.
When does the buck ever stop with you, Commissioner?
Well, I tried on many occasions, Mr O'Brien, to try and get the youth justice system properly funded.
I see you shielding a lot of responsibility, avoiding a lot of responsibility, pointing down and pointing up, but not ever copying it sweep.
No, that's not true.
Your approach and management damaged these children, Commissioner, I suggest.
That's your opinion, Mr O'Brien.
You were in charge of a depleted and dysfunctional juvenile justice system, and you knew it at the time, and you tried to avoid taking any responsibility for it.
That's incorrect.
The questions put by the learned counsel for Carlos is quite apt. As soon as there was any criticism, you went into attack mode, didn't you?
No.
I want to ask you about the restraint chair.
Safety chair.
Oh, it's restraint. That's right. You called it the safety chair. You changed the name, didn't you?
Yes, I did.
Yeah. No reason for that other than to conceal the real use of it. It
No.
restrains children, does it not?
No, it's a safety chair to be used, and I put some, you can see there's an email back to Miss Nobbs for the use of the chair and how it was to be used.
The nomenclature of the chair itself doesn't matter, because what this chair does is, when you see it in a picture, both confronting and disturbing. Do you accept that?
It is. There's no risk about that.
And it would have seemed that the majority of the Australian population, or at least a large portion of it, having seen it on Four Corners, thought the same thing. Am I right?
But Mr O'Brien, I prefer to be criticised for that than have to front up a coronial to tell a coroner why I didn't take action to prevent somebody taking their own life.
Yeah, you're aware that they don't use that chair in any other state or jurisdiction in this country except here?
I'm not.
Under your watch?
I don't believe that.
For children, you think that they use it elsewhere for children in this country, do you? Where?
Look, there's a lot of methods that are used, and in a lot of, we're probably the only jurisdiction that's got very poor infrastructure.
Did you, as the Commissioner, ever go and have a look at any empirical research as to the risks of this chair on children who are already traumatised and threatening to kill themselves?
No, but I can tell you that there's, from my knowledge, that chair has only been used on 4 distinct people, 2 adults and 2 juveniles.
I want to suggest to you that the use of this chair and the use on children was callous and it was cruel.
It was for safety.
It was inhumane and it was degrading.
It was for safety.
It put some of the most fragile and vulnerable children in your care in a position of more and more psychological and mental damage.
When you try to get a young person into support in early hours in the morning, and the hospital tell you this is not a mental issue, this is a behavioural problem, go back and manage it, you haven't got too many options. You know, I'm not really in favour either of a whole heap of officers or a couple of officers trying to hold somebody down that's trying to self-harm. I think that in itself is more traumatic than sitting somebody in the chair, having an officer sit there talking to the person while they're there, calm them down and then allow them out. Now, it doesn't look good, I know that. And one of the reasons why I put in to Ms Nobbs some fairly strict guidelines around using it, because I just didn't want the attitude that people would use the chair without some constraints.
Now, in March of 2015, my client was taken to an adult prison, and that chair was, he was placed in a chair like that with his spittled over his head. You're aware of it?
He was threatened to break his arm.
Yeah, and he hadn't actually hurt himself by that stage, had he?
But he was threatening to do so.
And he did it how many times? He said it once, didn't he?
I'm not sure how many times. The report to me was he threatened to self-harm.
And did anyone think that that stage, look, he's threatened to self-harm, let's take him to a hospital?
I'm not sure what the circumstances were, but he's threatened to self-harm, and that's what they did.
Do you think that that might happen from time to time with children threatening to hurt themselves where you might not put them in a chair?
And we did do that.
You didn't do it on that occasion. He threatened it once and he was in the chair.
And just keep in mind that the Alice Springs Correctional Centre is 26 kilometres from town, and in the middle of the night, it's not that easy.
Inconvenient, was it?
No, but it's about staff, available
Mr. O'Brien,
staff.
that was not a called for comment.
You know, it's easy in hindsight, Mr. O'Brien, to make some of these comments, but when you've got a young person threatening self-harm in the middle of the night, you've got a finite group of resources inside the prison. It might have been, at that period of time, that night senior had difficulty in trying to call on additional staff to deal with that. It is a problem.
I'm telling you, sir, he threatened to break his arm once, and within 10 minutes of that, he was in a chair.
Well,
That's it.
That's not the advice that I was given.
Well, that material will be before this commission, and that can be a determination for the commission. Do you understand that?
Yes, I understand that.
I want to suggest to you, sir, that your time as a commissioner, so far as it related to children in detention between the years of 2012 and 2015, was an abject failure.
That's your opinion, sir.
I want to suggest to you that you have not in any way been able to accept responsibility for the obvious and ongoing failings that existed within that system under your watch.
Mr. O'Brien, I think there's a lot of evidence there to demonstrate I did try to do things in that period. I did try with government to get resourcing. You know, it's easy to make those comments, but when you're trying to deal with this, with lack of resources and everything that was going on in the department, you know, it's easy to be critical 2 or 3 years down the track, but we did attempt to make real changes within the youth justice system.
And I want to suggest to you, last of all, sir, no matter how Dylan Voller behaved, no matter what he did, on each of those instances where the Children's Commissioner has found in his favour, and in relation to the use of that chair, none of it was justified or appropriate.
I don't agree with you.
Thanks, Mr. O'Brien.